Hello,
Yes, ma'am.
may I audible?
Yeah, yeah.
Okay, ma'am. Good afternoon, everyone. I think you all excited to listen our next speaker. So it's time to begin the next session without further delay. Our next speaker is enthusiastic, passionate, and energetic speaker, Advocate Gauri Boddu, ma'am. So, welcome, ma'am. Welcome in afternoon session in our one-day seminar in patenting in pharmaceutical challenges and case studies. So, once again, welcome, ma'am. Ma'am, currently serving as a legal IP head at IP Intellect Services, Pune. She also hold a BA LLB degree from Sinhagad Law College, Pune. She has extensive experience in various legal matters, including civil laws, family laws, criminal cases, domestic violence protection, and other legal areas. So, we are lucky to have such personality with us. Now, I request to Advocate Gauri Boddu ma'am to begin her session. So, ma'am, please start your session.
Thank you, ma'am, for introducing me. So I will start my presentation. I will review the PPT.
Add करू का?
Can you see my PPT, ma'am?
Yes, ma'am. Yes.
Yeah. So let's begin. So should I start with my presentation, ma'am?
Yes, ma'am. Start.
Yeah. So today we are going to study about patent law and its case laws. So first my presentation is about IPR. So what is intellectual property right? IPR refers to the legal protections granted to individuals or organizations for their intellectual creations such as inventions, literary and artistic works, symbols, names, images, designs used in commerce. These rights helps create or control the use of their works and encourage innovation by granting exclusive rights for a specific period. In intellectual property rights, there are different 4 5 types of laws which help us to protect our work created by intellect. So there are copyright, trademark, patent, geographical indication, and etc. So from that, today we are going to discuss about patent. So, patent. What is patent? Patent is an exclusive legal right granted to an inventor for an invention. It provides the inventor with the right to prevent others from making, using, selling, and importing, distributing the patented invention without permission for a specific period. Patents are granted to encourage innovation by providing inventors with a temporary monopoly over their invention in exchange for disclosing their ideas to the public. So, patent is made for protecting our work, whatever we have invented. So, it should not be sold or used by another person without our permission. A patent gives the owner rights to protect his work. So the invention includes like drug equipments, compositions, and etc. So now let's begin with the criteria for registration. For an invention to be patentable, it must meet the following keys criteria. So what are the keys criteria? So now first is novelty. Now, what does novelty means? The invention must be new and should not be disclosed or published anywhere in the world before filing date. Inventive step. There should be an inventive step in the invention. The invention must not be obvious to a person skilled in the relevant field of technology. It must involve a significant improvement over existing technology. Now, the second is industrial applicability. These are the criteria where you need to be fulfilled to file a patent. So the industrial applicability tells us about that. The invention must be capable of being used in an industry and should have practical utility. So it should be new, it should be inventive, and it should be industrial applicable. These are the criteria for patent registration. So now let's see the next slide. Now, what is the purpose of a patent? The purpose of a patent is to grant an inventor exclusive rights over their invention for a specific period, typically 20 years from the filing date. In exchange for publicly disclosing the details of the invention, the main objective patent includes, and also I would like to add, if provide protection for technological, it provides protection to technological ideas and also provides possibility of a reward not only for a creation of an invention but also for further development of an existing invention. Now let's see the what are the objectives. Now encouraging innovations. Patent incentivize research and development by rewarding inventors with exclusive commercial rights. Next is providing legal protection. It prevents others from making, using, selling, or distributing the patented invention without permission. Now, next is the economic benefit. So, the patent holder can commercialize their inventions, license them to others, or to sell the rights, generating revenue. Now, next is the technological advancement. By publicly disclosing patented inventions, patents contribute to the pool of knowledge, allowing future innovation to build upon existing ones. Competitive advantage. Companies can secure a market position by preventing competitors from copying or using the patented technology. Now, next is encouraging investment. Investors are more willing to fund innovative businesses if strong IP protection exists, ensuring a return on investment. So, these are the purpose of patent. These help us to register a patent, and these help us to protect our work. So now next, how a patent can be obtained. How a patent can be obtained. So these are the following steps to obtain a patent. Now first is an application. An application must file first file sorry an applicant must first file an application for a patent in the IP office. So there is a criteria. If inventions fall under matter which is excluded from patentability under national law, the patent application will be failed. So it shouldn't fall under a patentability national law. Now, what is the claim? If more than one patent applicant claims same invention, a patent will be granted to a first person. That is a first to file system. Now, in the patent office, there is an examination. A patent office must examine that the invention is disclosed properly and clear in the application. Everything should be written in the in the patent draft. The examiners examines the patent draft. And the second one is the description. A patent application must provide an adequate written description to enable a person skilled in art to practice the invention. So these are the following points where we have to look into before filing a patent, where we can obtain a patent by fulfilling these following steps. So now, what are the rights of a patent holder? A patent, an issued patent gives the patent owner right to prevent others. Likewise, I told you that it prevent others from selling, making, offering for sale in the country, in the another country, or importing into the country in which a patent is granted. Starts from the date of publication and last until the expiry of patent term. So now let's learn deep about it. So, what is patent related rights? In patent related rights, there are exclusive rights. What is exclusive rights? The patent owner has the exclusive right to make, use, sell, import, and license the patented invention. A right to license or assign. The owner can assign the patent to others from commercial use or assign ownership. Now, right to sue for infringement. If someone uses the patent without permission, the owner can take legal action. If someone uses your work without your permission, we can take legal action against that person. Now, right to seek injunction. The patent holder can request a court to stop unauthorized use. So, what is injunction? Injunction means that a person can be restricted for a time period from doing wrong. The injunction can be a temporary injunction, or it can be a permanent injunction, or it can be a mandatory injunction. Permanent means he can't do anything in future. He has been ordered by the court, that injunction has been granted, so the opposite person can't claim anything. So that is injunction. Injunction means to restrain a person from doing something. So now next, right to claim damages. The owner can seek monetary compensation for losses due to infringement. If there is some loss, if you are a patent owner and someone is using your patent without your permission, without asking you, or without knowing you, so on that basis you can seek compensation or damages through a court. So you have to file that petition for injunction and damages. So that is for specific performance. Now, right to oppose challenges patent. The owner can challenge other patents if they believe there is a conflict. Right to work the patent. Some jurisdictions require patent holder to utilize the invention within a specific time to prevent misuse of monopoly rights. These are the patent related rights which are given to a invention if a person has registered for a patent. So now next one is patent enforcement and its exceptions. Now there are legal remedies. As I told you, there are legal remedies that you can go through the court also. So now first, what is the first legal remedy is cease and desist notice. Now, what is cease and desist notice? A formal warning to stop infringement. If you are a patent owner and another person is copying your thing, so you can send him a formal warning to stop the infringement. Now, second one is patent litigation. These are the litigations which you file in the courts. Filing a lawsuit in the court. Interim injunction, as I told you, there are interim injunction, permanent injunction, mandatory injunction. Interim means temporary, permanent means it is permanently. So, what does interim injunction says? Preventing further use until a legal decision is made. If there is a suit, the suit has been filed. Until it is decided, the court grants interim injunction that the matter up to which it has not decided, till then there will be an interim injunction that the opposite person should not use the patent till the decision of the suit. Now, what is permanent injunction? A court order stopping further infringement permanently, which means interim means for a limited period, that is till decision of the suit, or it may be for a month or might be 6 months, and etc. And permanent will be till the end, forever. And what is monetary damages? Compensation for financial losses due to infringement. So there should be a monetary damages means if something wrong has happened and you have faced irreparable loss, there will be a monetary damages that another person has to bear it if the court has passed the order. So now what is seizure of infringing goods, removal of counterfeit or infringing products from the market. These are the legal remedies where you can file in the court a suit regarding the patent, about your design, and etc. Now, other are the alternative dispute resolution, where you don't want to go to the court and be present. So, by this area, it is very easy. outside the court you can settle the matter, or else you can compromise the matter. There is a mediation and arbitration. Parties where negotiate or settle disputes outside of court. Now patent licensing agreements, instead of litigation, the patent owner may agree to license the patent for royalties. Means you can give your patent license to someone else, and in return you can ask him for royalties, that this amount has been given and you can give me this for some small period. So in licensing agreements you can do this instead of litigation. Government and custom enforcement. So now patent office opposition proceedings. Third parties can oppose the grant of a patent, pre-grant or post-grant oppositions. Now if you have filed your patent in the patent office, third party can file the opposition where he can say that my patent is also related to that, or there might be anything opposition. So it is related to that patent office opposition proceedings. Now then after his opposition comes on that, we file our counter statement and it goes to the hearing, and thereby it our matter get decided whether our patent is accepted or whether our patent is refused. So it is patent office opposition proceeding, likewise the court proceedings. So now custom authorities. Some jurisdictions allows customs to block infringing imports. So there are some custom authorities who doesn't allows the patent to get patented. So now next is the exception, like general exceptions. Exception that the patented invention can be used other without authorization by others without authorization by a patent owner. Where there are exceptions where a person can use a patent without authorization, like for example for research, for experiments, use of patented device, for forming some parts of vessels or anything regarding aircraft, land vehicles, or it might be anything related to anything. If the invention is created but the person want to just refer his work or want to study in depth, so he can use our patents. So now next is the trade secret and public domain in patent law. So now a trade secret refers to confidential business information that provides a competitive advantage. Unlike patent, trade secrets are not publicly disclosed but remain protected as long as secrecy is maintained. An unauthorized use of information by third person can create an unfair practice and violation of trade secret. Conditions of trade secrets are: the information must be secret, must have commercial value, must have been subject to a reasonable steps by the rightful holder. So, trade secret is related to secrets which are confidential in manufacturing, in industrial, in commercial. It may be anything in business. So, it should not be open outside. For example, the Coca Cola formula is a classic trade secret. The formation of Coca Cola forming, that is a trade secret. Now, public domain in patent law. What is public domain? The public domain refers to invention, knowledge, or intellectual property that are not protected by IP rights and can be freely used by anyone. But if you want to protect your invention in other country, for that you have to file in another country a patent application, or else it can go into public domain. If you want to protect your patent, so in another countries also you have to file applications. And the example for public domains will be expired patents like aspirin, common engineering methods and scientific formula, open source software, and creative common works. Public domains mean where you, if you have filed a patent and the expiry it has been expired, you have not renewed it, so the work goes in the public domain. That is public domain. So now let's see the next topic. What is patent infringement studies? Section 104 to 115 of the Patents Act 1970 provides provision regarding patent infringement. It deals with legal proceeding and defenses related to patent. So section 104 to 115 are the sections where it deals with legal proceedings and defenses related to the patents. The Patent Act 1970 does not provide specification as to what would be considered an infringement of a patented product, but it lays down two kinds of activities which, when committed without the consent of the patent holder, would constitute infringement. So, these are the patented products. Now, making, using, offering for sale, selling, importing the patented products. These are the infringement of the patent. Using the patented process or using, offering for sale, selling, or importing the product directly contained by that process is the infringement. If someone is using it, making it, offering for sale, or selling it without your knowledge, it goes in infringement. Now, what is patent claim? A patent claim is a patented a pharmaceutical composition compromising element A, element C, and element B and element D. Competitor can sue if they own any of the A, B, C, or C. You can sue if competitor makes uses, sells, offers to sales or import the A plus, B plus, C plus. So that is patent claim where you have the elements, but someone is using it and selling it. So that is where you can find the infringement. Patent infringement. If any person exercises the exclusive rights of the patent holder without permission within the country of patent, grant, and during the patent term, a person is liable for infringement if his product or process is same as the patented invention. I already told you guys that using it or making it or selling it in the same way where it has been patented, it is an infringement. Now, as claims in a patent define boundaries of the invention, claimed a product or process patent will be infringing if it falls within the scope of a claim in the patent. The patent claims are that making it, using, selling, offering, or importing. Therefore, understanding the meaning and scope of patent claim is important for determining infringement. The claims helps us to determine that is our patent getting infringing or not. So now there are the types of the patent infringement. So these are the types where direct infringement. So we will look into the examples in on the slides. Now let's see what is direct infringement. When a patented product or method is used, marketed, sold, offered for sale, or imported without permission of the patentee during the terms of such a patent. It constitutes direct patent infringement, where he directly uses it, directly marketed it, or sold it, or offered for sale. That is direct infringement. Now, what is literal infringement? As the word literal signifies, literal infringement is the type of direct patent infringement where every component of the patent specifications is taken to constitute the infringing product or process. In other words, all the claims in the patent specification match the features of the infringing products or process. Literal means exactly the same, but there are one or two components are missing. That is literal infringement. We will see the examples in the another slides. And now non-literal infringement. Non-literal infringement is the type of patent infringement where the infringer has made an equivalent product or process to the patented product or process and has been using, selling, marketing, offering for sale, or importing the same without permission of the patentee during the term of such a patent. So these are the types. Now we'll discuss more about these in brief. So now direct infringement. It directly states that the third party has willfully or intentionally stolen the technology from the inventor without his prior permission. It occurs when someone directly makes, uses, or sells the patented invention within the country. Now, directly means exactly the same, has not missed any component, has used the same process, has used the same procedure to make it, and has used same components. That means direct infringement. So this is the example of or direct infringement. So now this is the patented product. This is a burger. It contains two slice, cheese slice, edible salad meat product, which is there are each product, each content, each ingredient in that. So if someone stole this in the same way it has been made by A person, but B is stealing that thing, that procedure, same to same is making like that, then it is a direct infringement. So guys, this is the direct infringement example. So now next, literal infringement. Literal infringement occurs when an accused product or process directly falls within the scope of a patent's claim without requiring interpretation under the doctrine of equivalence. In this case, every element of a patent claim must be exactly present in the accused product or process. So, in literal infringement, there should be one missing component where it is a literal infringement. Now, if all elements of a claim are literally present in an patented product or process, claim 1, a pharmaceutical composition compromising element A, B, C, D. But if that is patented, but if opposition is using A, B, and D but not using C, then it is a literal infringement. Now, a drug composition compromising compromising element A, B, C, and D. But he's not using B, but he has used A, C, and D element. So this is literal infringement. That something is missing from that. Determination of literal infringement is done by comparing elements of a claim to those of a product or process one on one. So this is the literal infringement example. So now above you can see there is a patented two slices, cheese, edible salad, meat product. But in claim 1, it is exactly the same. So it is a direct infringement. In claim 2, cheese is missing. So it is a literal infringement. So this is the example of literal infringement, that something is missing. If there is not edible salad, you can say that it is a literal infringement because there are two components missing. But you have not exactly copied like that. So it is a literal. Now let's see what is equivalence infringement. Equivalence infringement is a concept in patent laws that extends the scope of patent protection beyond the literal wording of the claims. It applies when an accused product or process does not fall strictly within the claim language but performs substantially the same function in substantially the same way to achieve substantially the same results as the patented invention. So in this, he has used the same way, but he has changed something in that component. So it is equal. He has used the same way, he has used the same ingredient, but in that ingredient there is something missing. So it is equivalence infringement. Through this example, you might understand. So patented is that two slices of bread, cheese, edible salad, and meat product. That is a patented product. Now you can see the claim to, where the opponent has used the cheese flavored dressing. He has used the cheese, but he has is used in the different form. So it is a equivalence infringement. So yes. So this is that he has used the flavored cheese in the dressing. So it is a legal equivalent. It is a equivalence infringement. So let's see the next doctrine of equivalence. So now what does doctrine of equivalence says? The doctrine of equivalent is a legal principle that allows a patent holder to claim infringement even when the accused product or process does not literally fall within the patent claim, but is functionally equivalent to the patented invention. A person is liable for infringement even though the infringing device or process does not fall within the literal scope of a patent claim, but nevertheless is equivalent to the claimed inventions. The difference between a feature in an accused device and the limitation literally recited in a patent claim may be found to be insubstantial if the features in the accused device perform substantially the same way to yield substantially the same result as the limitation literally recited in the patent claim. So if there is a patent in which it has made in the way the function which has been used by making the invention, if someone copies that to make same literally the same, where it is it functions the same, it is substantially same, the results are also the same, this is a doctrine of equivalence doctrine of equivalent infringement. So now let's see what is the next topic, determining patent infringement. So in detail, it has given over here what we have to what we have to see in doctrine of equivalence. Doctrine of equivalent, evaluating if the accused product process is equivalent to the patent claims. How to determine if it is a doctrine of equivalent? Let's see what does it means. When a patent is granted, its claims define the scope of protection. If another product or process does not exactly match the claims but performs substantially the same function in substantially the same way to achieve the same result, it may still infringe under the doctrine of equivalent. This doctrine prevents minor variations from escaping infringement's liability. As I said, the product or process does not exactly match, but it performs substantially the same, it functions in the same way. This is the doctrine of equivalent. Now, the key for evaluation criteria for equivalence. Now, FWR. What is FWR? The function way result test. Does the accused product process? Now, following are the steps where we can determine that has the person made a infringement related to doctrine of equivalent, perform the same function as the patented invention, work in substantially the same way, achieve substantially the same result. These are the points we have to see if it is infringing our patent. Now, insubstantial differences test. Are the differences between the patented invention and the accused product minor or insignificant? Now, prosecution history estoppel. If the patentee narrowed the scope of their claims during the patent examination process, they may be prevented from using the doctrine of equivalent. These are the things where we can determine whether whether the patent is infringing or not. So let's see the next slide. So wait a minute, just guys. I'm unable to start my next slide. Just a minute. Next slide is me.
Okay.
He says.
Okay. Jennifer.
बरोबर. ठीक आहे. Okay, so type of patent infringement. So this occurs when a party encourage, aids, or facilitates another party in infringing a patent, even if they do not directly infringe the patent themselves. So for these, the examples are supplying components, materials that lead to unauthorized use of patented invention. A company provides instruction or incentives to a third party to manufacture a product that infringes a patent. This is indirect and induced infringement. Indirect infringement is a type of patent infringement where the patentee rights are involuntarily or unwillingly infringed by an infringer. It may so happen that some amount of deceit may be involved too. So, as I have told you the example that supplying components, material that lead to unauthorized use of patented invention. A company provides instruction or incentives to a third party to manufacture a product that infringes a patent. These are the examples. Now, what is contributory infringement? This type of infringement happens when an indirect infringer supplies a direct infringer with a part that has no substantial non infringing use. In other words, the indirect infringer, knowing that such essential parts, components will make the manufacturing cause direct infringement, still supplies such part. The manufacturer supplies the parts knowing that it is a direct infringement. It is contributory infringement. So now let's see the next slide. Induced infringement. What is induced infringement related to? These are the examples. A middle party induced infringer enables or help influence or induce a third party direct infringer to participate the patented invention. If someone is participating in the invention, help could be a form of assembling the patented product, preparing instruction of consumer use, providing instructions to produce patented invention, or licensing plans or process which enable the licensee to produce the patented product or process. These are the indirect infringement. So now let's see the contributory infringement. Contributory infringement refers to a legal doctrine where a party is held liable for indirectly infringing IPR by aiding or facilitating another party direct infringement. If a party contribute to the infringement of a patent claim may be held liable. Accordingly, a supplier of a particular component is held liable if the component constitutes a material part of the invention. The supplier was aware that the component was especially made or adapted for use in an infringement of such patent. If contributory infringement, it is mostly importantly related to the material part. The component is not a staple article and the component was used to commit at least one act of direct infringement. So example is that a party offers to sales or supplies a component that is specifically designed for use in a patented invention. So this is the example that his party is offering to sell or supply a component which is specifically designed for a patented invention. Most importantly, he is selling the parts of the company of the patented materials. So now next see the another type of infringement. So another type of infringement is that willful infringement. So what is willful infringement? As the name suggests, willful infringement is the type of patent infringement in which the infringer intentionally or willfully disregards and violates the patent rights of the patentee. In other words, if the infringer had knowledge of the patent and still violated the same, then such an infringement shall be a willful infringement. In this, that the person has the knowledge that he is violating. So this is a willful infringement. So this I will give some examples on this. Company A is a patent holder, owns a patent for a unique gesture based unlocking system for smartphone, and someone is using that. So now company B is a competitor, launches a new smartphone with the exact same unlocking system. As I told, he has the knowledge, but he is still stealing the same thing which has been done by the A, a patent holder. Now, which in this willful infringement, that the person should have the prior knowledge, where they have internally discussed and has also ignored warnings, and also ignored warnings in warnings if A is warning B by sending him notice disease and disease letter, but this B person is ignoring, then this is a willful infringement. Prior knowledge, in that prior knowledge, that B has internally discussed with A and has the knowledge of the same, but he is not listening and and is infringing, so he has the knowledge. And in deliberate copying, he is deliberately copying the invention which is already patented. So this is the willful infringement. So now let's see the next slide. Determining patent infringement. How to determine that a patent is infringing? Claim analysis, comparing the patent claims with the accused product process. A process for preparing a flavored dried fruit product, said process compromising. Treating a dried fruit with an acidulate being selected from the group consisting of a tartaric acid, malic acid, citric acid, ascorbic acid, phosphoric acid, and fumaric acid in an amount and for a period of time which is sufficient to substantially remove the natural flavor of the dried fruit. If someone is copying the process but has is using some different process to make his product different, from that we can determine that the patent which has already the invention which has already been patent is infringing. So now next, dehydrating the treated dried fruit to obtain a desired moisture content. Treating the dried food during step A or after step B with a flavoring agent having a flavor which does not substantially correspond to the natural flavor of the dried fruit. Now A has created has sorry A has invented a product where it contains each flavors and everything and has in different flavors, but B wants to copy or steal the same process. He is stealing the same process, but he is trying to make his product different from the A's product. So through that, all the components are same, but he is using something different agent with that product. From that, we can determine that he is infringing the patent. So analytical methods for patent infringement. Determine the claims literal language scope. To evaluate if there is a literal infringement, compare the claims as they should be interpreted with the accused device or method. Apply the law of equivalence to interpret the claim scope if there is no literal infringement. So I will give example on this. Word for word, match exactly. A patented drug formula like A plus B has an accused as an versus an accused product A plus B. Like A has used a formula and B is copying the same, like exactly, is using the same method and it match exactly, so that it's a patent infringement. Now let's see this second example. Substantially the same function in the same way to achieve the same result. As I told you guys, that it has the same result. The process might be different, but it has the same result, substantially same, function same. A patented process uses a chemical solvent by X, but the accused infringers uses a chemically similar solvent Y. The process, a patented process has used a chemical solvent X, and the accused has used the solvent Y. As I told you, that patented invention uses the solvent X and the B is using Y, but the product is same. Through this, we can analyze that it is a patent infringement. So now performing your own infringement search in 5 easy steps. So let me tell you. Now identify the patent in question. So this is the first step. In this first step, in conducting a patent infringement analysis, is to identify the patent that you are potentially infringing on. This may involve searching through public databases such as the US Patent and Trademark Office USPTO database to find relevant patents. Through this, we can identify the patent. Read and understand the patent claims. Once you have identified the patent in question, it is important to thoroughly read and understand the claim made in the patent. These claims outline the specific elements that are protected by the patent, and it is these elements that you will need to compare to your product or process to determine whether there is infringement. So, through this, you can understand that it is infringing or not. So now compare your product or process to the patent claims. Once you have a true understanding of the patent claims, you can begin the process of comparing your product or process to these claims. You want in this step you where you compare your product with the process to the patent claims. So now the next steps are performing your own infringement search. Okay, so let's continue. This may involve breaking down the claims into individual elements and comparing each element to your product or process to determine whether there is a match. In comparing, I told you that we have to compare our process and product. That does our process or product is matching to the first product which has been already invented and has been patented. So now second, consider and potential defenses. If you do determine that your product or process may infringe on the patent in question, it is important to consider any potential defenses that you may have. And you can also seek legal counsel if you are still uncertain about whether your product or process infringes on an existing patent. It is an innovative idea to seek the advice of a qualified patent attorney. They can help you to fully understand the legal implications of your situation and provide guidance on the best course of actions. So, these are the 5 steps for performing your own infringement search. So now let's discuss about the second topic. So now for patent, there is a patent corporation treaty. So what are the provisions and obtaining patent worldwide? So let's see. In Article 31 of the PCT gives you the provision for the demand of the preliminary examination by the RO, whose demand must be made separately from the international applications. Article 33 lays down the objectives of examination in a detailed form which serves the purpose of the preliminary inquiries. Article 34 of the PCT talks about the procedure to be followed for the examination, and the applicant has the right to communicate orally or in a written form with the treaty. So PCT is a treaty where the patent where the patent can be filed internationally or worldwide. At any point of the examination, the inverter can amend the claims, description, drawings, and anything in between for which the rules have been stated in Article 41. The applicant will receive a written statement from authority if invention clarifies the requirement set forth in Article 33(1). If these requirements are not fully fulfilled during examination, the authority can call the inventor to amend the claims. So, patent cooperation treaty, how it works, I will tell you. Filing a simple international application, which becomes a multitude of national applications. But there are some steps. So the next step is that the countries, if even if you are filing your international application, the countries should accept the application, and then only the patent will get registered in that countries. Until then, you can't protect your invention in that country. So it is in on the countries that they should accept the application or refuse the application. Once it is accepted, it is good for you. Your patent will get protected in those in foreign countries. If it is refused, you can't do anything. Your work will be patented work will be used by them. So obtaining patent worldwide, there are some treaties which has been made. European Patent Organization. In European Patent Organization, you have a single European patent application effective in all participating member states by filing. In European countries, if you have filed one single international application, your patent will get accepted, whether accepted or whether refused. And if accepted, your work will get protected in those countries. So let's go to the next topic, defenses. What are the defenses? A personal person falling within the scope of a defense will not be able for infringement, though his product or process in infringing. Invalidity, experiment. As I told you, these defenses are that some work can be defensed and some work can be go to the public domain. Like in defenses, it is invalidity, experiment, research or education, government use, patent exhaustion, patent misuse, and inequitable conduct. So these are the defenses. So there are some work also which goes into public domain. Experiments also goes in that. Research or educations also contains in public domain and also in defenses where you can defend your patent. So now litigation. So you might may know that the civil court has the jurisdiction where it deals with the civil matters related to patents, and even also for appeal the high court has the jurisdiction where we can file appeals if our matter doesn't get solved in the civil court. So civil court and high court has the jurisdiction to look into these matters where civil court files injunctions, permanent, temporary, and etc. So now let's see the case studies. So this is the case of Vet versus Sun and Teva. Pantoprazole 20 mg and 40 mg delayed release tables Protonics. In 2000, WIT's NDA Protonics got approval. Nycomed licensed the molecule's patent to WIT. In 2004 to 2005, Teva and Sun filed ANDA to market their generic versions of Protonix. With filed suit against Teva and Son in the US District Court, alleging infringement of the basic patent US, seeking declaratory judgment and injunctive relief. As I told you, injunction means what? What is injunction? Filing of the lawsuit stayed final FDA approval of Teva and Sons ANDA. So in 2007, the US District Court denied with motion for preliminary injunction based on the limited record before it. The court did not rule on the validity of the patent. So next. Huh. In 2007, following the court's denial of a preliminary injunction, Teva and Sun launched their generic version of Protonix tablets at risk. In 2008, to affect sale of generic players, Beth launched her own generic version. And in 2010, the district court confirmed that the patent is valid and rejecting allegations by the generic manufacturers that the patent was invalid as obvious. In 2012, With filed a claim seeking $960 million in damages and $2.1 billion from Teva for loss of profit due to generic launches. Sun Pharmaceutical Industries is expected to make a provisioning of around $320 million towards a liability claim by With. So this is discussed in that case study. So now let's see the another case study. This is Hoffman La Roche versus Cipla. Erlotinib hydrochloride 2500 150 mg tablets Tarkeva. So this was between Roche and Cipla. In 2007, product patent for erlotinib HCl, an anti-lung cancer drug, was granted in India. This was filed by Pfizer and OSI Pharma and licensed to Hoffman La Roche. Hoffman La Roche launched Tarceva in India. So Cipla launched generic version of erlotinib HCl tablets, Erlosip, in India. In 2008, Roche filed suit against Cipla in High Court, alleging infringing of IN 774, restraining Cipla from manufacturing and marketing Erloslip. Cipla argued that IN 774 patent was invalid as similar structure compound is known in prior art and hence erlotinib HCl is not novel and inventive compound and asked for revocation of IN 774. So as I told you guys that the patent should be novel, which is new, it should be inventive. This was referred in that case in 2009. High Court took two issues into considering patent validity for revocation and patent infringement by Cipla. Now we are going to study the next case, which is Novartis versus India, a landmark patent case that will make you understand the legal battle over affordable medicines. So, introduction. What is this case about? Novartis is a Swiss pharmaceutical company that developed the drug Gleevec, imatinib mesylate. It applied for a patent in India to protect its drug from being copied by generic manufacturers. However, India rejected the patent, saying the drug was not a new invention. They wanted to say that it is a copied invention. So this case became a fight between corporate patent and public access to affordable medicines. So what happened next? So what is Gleevec? Gleevec, also known as Gleevec in the US, is the brand name of imatinib mesylate, a drug used to treat certain types of cancer, especially chronic myeloid leukemia (CML), a type of blood cancer, and gastrointestinal stromal tumors (GISTs), a type of stomach or intestinal cancer. So Gleevec is a medicine used to treat certain type of blood cancer, leukemia, and tumors. It was first developed in the 1990s and sold at a high price. Many patients in India could not afford the original medicine. Generic versions were much cheaper, helping more people get treatment. So, Gleevec is a targeted therapy that works by blocking a specific protein called BCR-ABL tyrosine kinase, which cause cancer cells to grow. By stopping this protein, Gleevec prevents cancer cell from multiplying, helping to control the disease. It considered a breakthrough cancer drug because it turns CML from a fatal disease into a manageable condition with long-term survival. So this is Gleevec. Why did Novartis apply for a patent? Why did he apply? A patent would give Novartis exclusive rights to sell Gleevec in India. So he wanted to sell that Gleevec in India. This means no other company could make or sell a similar medicine. Novartis wanted to protect its drug and stop generic companies from making cheaper versions. So he wanted to protect his drug and stop making generic companies in a cheaper version. So India Patent Office rejected the application under Section 3D of the Patent Act. So now let's see what is Section 3D. 3 subclause D. It prevents evergreening. Companies cannot get a patent for minor changes in an existing drug. It requires enhanced efficiency. The new form of a drug must work significantly better than the old one. India's aim to encourage innovation but stop unnecessary patents that keep drug prices high. So in India, the drug prices are not affordable because India's population is so much, as you know, so no one can offer that much high prices. So therefore, they rejected the applications because the Gleevec prices were too high. So since Gleevec was only a slightly modified version of an older drug, it did not qualify a patent. So now what is the legal battle timeline of the case? In 1998, Novartis applies for a patent in India. In 2006, Indian Patent Office reject the application under Section 3D, where you might understand what 3D is, that prevents evergreening, requires enhanced efficiency, and what is India's aim. So companies cannot get a patent for a minor changes in an existing drug. Under Section 3D, that is that there should not be a minor change in a drug. There should be a totally completely change, but there shouldn't be a minor change. That is Section 3D of the Indian Patent Act. So in 2007, Novartis challenges the decision in the Madras High Court, and in 2009 the case moves to the Indian Supreme Court. As I told you that they have the judiciary, so they have the jurisdiction to handle those matters. So the Supreme Court upholds the rejection, ruling that Gleevec does not qualify as a new invention because it was not totally new. There was only a minor change in that drug. So due to which the Supreme Court has rejected the same. Now Supreme Court verdict. What was the Supreme Court verdict in 2013? Novartis lost the case. The court said Gleevec was not a truly new invention. India's patent law aims to protect patents by allowing affordable medicines. This ruling helped keep the price of a cancer treatment low for thousands of patients. It also set an example for other developing countries to balance patent and public health. So, this was the Supreme Court's verdict that they want to make the medicines affordable and to keep that in low prices where every can afford it. And that was not a new invention, it was not completely different, it was there was only a minor change in that. So due to that, the Supreme Court gave its judgment saying that it is not accepted, and they rejected his appeal. And impact of the case, why is it important? What is the impact of the case? What they wanted to prove? What does the Supreme Court wanted to prove? That there should be affordable medicines that allowed Indian companies to continue making low cost generic drugs. Stronger patent laws ensured patents are only given for truly new and innovative drugs. As I said you, there are criteria. That three criteria are novelty, inventive, and industrial applicability. So it should first fit in that criteria, then only you will get your patent registered. So global influence. It inspired similar policies in other countries. to prevent evergreening and pharmaceutical industry's response. Some companies opposed the decision, fearing losses, but it encouraged real innovations. Some companies also opposed the decision. How is this possible? But no, Supreme Court has given the judgment that it should be affordable to everyone, it should be new, it should be balanced. Therefore, this was given by them. So, what is the conclusion? The Novartis versus India case was a turning point in global patent law. India protected public health by rejecting unnecessary patents. It ensured that essential medicines remains affordable for millions. A landmark case showing the balance between pharmaceutical profits and patent rights. So, Novartis case was a turning point where it gave everyone a tough decision that it should be new, it should be affordable, and that essential medicine should be remains affordable for millions of people. Where can everyone buy this? So, guys, now I had completed my presentation. I would like to end my presentation over here.
Thank you, ma'am.
Yes, ma'am. Can you see my screen?
Yes, ma'am. Yes.
Yes, am I visible now?
Yes, ma'am. You are visible.
Yeah.
Any question from audience? Audience, have you any question? Okay, ma'am. One question from audience. What is the exact issue?
Hello.
Hello, ma'am.
Yes.
What is the exact issue of Novartis case study, ma'am?
Sorry, I'm not able to hear you.
Exact issue of Novartis case study, ma'am.
The exact issue is that the product should be new.
Okay.
In Novartis case, it was not new. It was
Okay.
there was only a minor change in that drug. As I told you, there are criteria that it should be novelty, it should be inventive, and it should be industrially applicable. So in that drug, there was only minor change, but it was not an invention.
Okay.
So this was in the Novartis case.
Okay, ma'am. Okay. Ma'am, to avoid like this issue, any rule regulations is there or not?
If you want to file your patent, you have to completely see to the criteria what has been given. The three criterias you have to follow the three criterias and innovate new something invention that should fit in these three criteria, and you can get your patent registered.
Okay, ma'am. Okay.
Yeah.
Thank you. Any more question? Thank you, ma'am,
Yes.
for
Yeah.
thank you, ma'am, for sharing your knowledge, informative knowledge with us. Your
Yeah.
insight and valuable time are truly appreciated for providing such informative session about the infringement in details. So, your expertise is not just theoretical; it's a driving force for real world solution. So, thank you, ma'am. Thank you very
Yeah.
much.
Yeah. Yeah. Thank you.
Now, the last part of our session, as we come to the conclusion of today's seminar, I would like to extend my heartfelt gratitude to other Shikshan Prasarak Mandal's management, Sudhiranna Patil sir, Principal of KT Patil College of Pharmacy Dharashiv, Dr. Amol Joshi sir. Sir, thank you, sir. Also, Chief Coordinator of today's seminar, Dr. Aruna Devi Biradar ma'am. So, thank you, ma'am. Also, our esteemed guest, Dr. Mahesh Jadhav sir, Miss Ankita Sharma ma'am, and Miss Advocate Gauri Boddu ma'am. Thank you, all of you. Thank you very much. Also, last but not least, I'm very thankful to all faculty members and other participants. Thank you for making this seminar is a grand success. With this, I conclude that today's seminar is over. Have a great day ahead. Thank you, one and all, once again.